Hello and welcome back. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on estate planning, trusts, property, legacy, family, and everything else on my mind. This is an exciting episode for me for two reasons. First, this is an episode, I think this will be the first of a few episodes. And second, to talk about this subject, I thought I'd bring in a guest. So please welcome Hunter Glenn, our colleague in our group who does a lot of work in this area. I especially rely on Hunter when a client wants to incorporate charitable giving into their planning, and also when a client has a private foundation or other entity and they need advice on how best to structure governance and distributions. Hello, Hunter.
Hi, Steve. Thanks for having me. I'm excited to be here.
Well, great. Our audience knows that on this podcast, we talk about family and what's on our minds. So before we get started, I'm going to ask Hunter about both those things. Hunter has a young daughter, Garrett, at home. Hunter, what's Garrett up to these days?
Gosh, Garrett is on the move. She just turned 7 months, so she's starting to work on crawling. But Google actually tells me what she's doing is more called scooting. In any event, we're having fun watching her learn all of her new tips and skills.
Oh, that's so great. So here in this episode, we're going to be talking about charitable planning. How does this topic typically come up during your conversations with your clients?
They may want to make a gift at death, or if they're married, a gift at the death of the survivor of the two of them, or they may want to make a gift now. I find that a lot of clients are exploring lifetime gifts because then they get to see that gift enjoyed and used during their lifetime. And tax planning might be a factor the client considers. If they make the gift at death, there's a charitable deduction from estate tax. And if they make the gift during life, there's a charitable deduction from income tax. There are limits to those income tax deductions, though, and those depend on what type of asset is contributed, the type of receiving organization, and a few other factors. But we actually find that charitable planning shouldn't just be about saving taxes. That is, if the client only wants to save taxes, there are usually other opportunities they could use to address that. So in this case, the client has a specific charity in mind or a specific cause in mind. And then I talk to them about the best way to structure that.
Oh, that's great. When the client brings this up, I think of all the different strategies here. I'm actually looking at my notes of all these strategies: outright gifts, gift agreements, donor advised funds, private foundations, charitable lead trusts, charitable remainder trusts, and variations of all of those. And we don't want to forget things like a letter of wishes or a mission statement for a charity or foundation, and ways to make sure the donor's intent is carried out in the future. I did a recent episode on a letter of wishes for a trust, and a similar technique can be helpful with the foundation, maybe as a kind of mission statement for the private foundation. And by the way, I think this looks like a summary of all the different episodes we'll do in the future. So anyway, of all these strategies, what do you start with your clients?
I usually just ask about an outright gift. They could give that money to the charity, and then it's the charity's to use. The donor can still specify some general guidance for the use of those funds, but it remains a pretty simple transaction.
On this podcast, we also like to talk about pitfalls. What are some potential problems or pitfalls with that kind of simple outright gift?
Well, because it's an outright gift, then once the gift is made, the donor doesn't usually have standing to enforce the gift, like if the charity changes its mission or folds up.
I can see you're getting to that recent case we talked about in our practice group meeting. That's Derblom versus the Archdiocese of Hartford. The full case citation is in the show notes.
Right. Yeah, it's an interesting case because it shows what might happen if the charity actually winds up. And just to give a little background, here, in his will, Fred Reddick left the residue of his estate, a total of about $4.7 million, to Our Lady of Mercy School. We'll call it just OLM for short, a Catholic school in Madison, Connecticut. The will directed the residue of his estate to OLM at 149 Neck Road, Madison, Connecticut, or its successor for its general uses and purposes. But 2 years later, the Archdiocese announced it was closing OLM. Various interested parties, including former students and students' parents, formed Our Lady of Mercy School of Madison, Inc., which they alleged would be the successor to OLM. And they brought an action against the Archdiocese based on various theories in order to recover that $4.7 million and apply it to the new school. The Archdiocese then moved to dismiss, arguing that those parties lacked standing. And then a trial court granted the Archdiocese motion to dismiss because of their lack of standing, and the appellate court affirmed. Most importantly, though, the court reasoned that this was an outright gift, not a trust, and therefore the parties lacked standing to have the school reapply their gift after its closure. The court also held that the Attorney General had the sole authority to enforce the gift and that the plaintiffs did not qualify for any applicable exception.
Yeah, so hindsight is 2020, and we don't want to be too critical of everyone involved in that process initially. But looking back, what are some things they could have done differently here, maybe as part of that initial planning process?
I'd actually just start with a conversation that Mr. Reddick could have had. If he had said he wanted to leave a gift to a school, that could have been a great time to remind him that the school could wind up or change its mission. And then that typically prompts a conversation of what the client would want to have happen in that case.
Yeah, that's a good point. And even one step further, I like to include that kind of comment in a letter or memo to the client summarizing the strategy. I think that's helpful because that way, if in the future the school does wind up, and if people are wondering what to do, you have some documentation of what the settlor's actual intent was. But what if you bring up that question to the client about the charity closing down, and the client says that he or she would want to make sure the gift is used for another purpose if the charity closes down?
So there are lots of ways to build in a structure for that kind of a charitable gift. The client could set up a private foundation or a donor advised fund, and then that entity can transfer assets over time. But an even simpler place to start could be a gift agreement.
Yeah, I like to talk about gift agreements. It can be a really useful tool in lots of scenarios. As we think about it with clients, even if the funds first go to a donor advised fund or to a private foundation, the funds will eventually go to charity. So if the donor intends that there be a large gifts where they want to make sure the funds are used for the intended purpose, a gift agreement can be really useful.
I agree. In this case, as an alternative to making an outright gift, the client or the client's private foundation could have entered into the gift agreement with the charity. And that agreement can be pretty flexible. In fact, the donor doesn't even have to commit to the gift in order to have that agreement. The agreement can just provide that if the donor ever makes a kind of gift, then the funds would be used for the purposes outlined in the agreement. And that agreement can address all kinds of issues, such as who has standing to oversee or question the gift's application, what happens to the funds if the charity changes its purpose or dissolves, who receives notice and reports on the gift. It can cover whether the donor is to receive any acknowledgement of the gift and how that acknowledgement or publicity is to read. And then also it could address whether and how naming rights could ever be changed by the charity. So bringing it back to the case, Mr. Reddick could have entered into a gift agreement during his lifetime that contemplated this gift at his death. And the agreement could have outlined what happened to the funds if the school ever closed.
Well, do you think there's any things that the gift agreement can't or shouldn't do?
Yes, so while we have that flexibility, there are limits. For example, the gift agreement shouldn't give so much control to the donor that the IRS disallows the charitable deduction. And there's been some cases, and they each have pretty complicated facts, but there have been cases where a court has disallowed a charitable deduction.
Yeah, and here's another question clients often have. What does this gift agreement even look like? Who actually drafts it?
Steve, at the end of the day, it's just a contract between the two parties, and there's different ways to approach it. The charity might offer to draft it, in which case we can then help the client review it and think through what, if any, additional provisions they would like to see included. Or we could draft the gift agreement based on our preferred language and then wishes we know the client has.
Hunter, thanks so much for joining us and all these insights. You and I could talk for a long time. I'd love to hear more of your thoughts on these outright gifts and gift agreements, and we'll talk more about other charitable planning. But I think we might want to wrap it up here. On this podcast, we try to leave the listeners with a takeaway or some thought exercise. So maybe I'll just pose that question to you. Is there anything you'd like to share with them right now to get them thinking about these issues?
Maybe just to think about the case we just described or a similar case where the charity changes its mission or closes. The donor should ask if they care about that. And if they are concerned about that, then a gift agreement or another structure might be a good thing to build into their gifting strategy.
Well, this has been great, Hunter. Thank you for being our guest here on the podcast. I'd love to have you back again to talk about some of these other charitable techniques. I'm looking back at my notes. So far, I have a good list: donor advised funds, private foundations, charitable lead trusts, charitable remainder trusts. And we don't want to forget about how to structure a mission statement for the private foundation, or how to modify a foundation, or how to set it up so there are limited ways to modify it. And I'm sure you've got a couple of ideas too of good episode topics.
Yeah, there's plenty to cover here, so that would be great. I look forward to it.
Well, great. Thanks again. I'm Steve Murphy, here with Hunter Glenn, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.